Any mention?
May please, Your Lordship. Your Lordship, I may be permitted to move an unlisted motion. There is urgency in this matter, Lord, because the trial court has fixed the date today for release of 16 crores land compensation to persons who are not entitled.
16 crores?
16 crores.
With special judicial officer?
Special judicial.
From which place?
From Shillong.
Okay.
Much obliged.
But you give notice to...
Yes, we have given notice to the state.
Item number 20, Lordship. Last
Item?
item. 20. I am for the respondent, Lordship.
On this side. She. On this side.
I am for the respondent, Lordship. Respondent 5, Lord, private respondent, Lordship. Sorry, I forgot.
Yes?
No objection.
objection.
Because I used to be the objection, Madam. I'm for the state.
2 weeks, yes.
Last item.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 10 and 11.
Where's Mr. Hassan?
He's out of his station, Your Lordship.
They have informed me, so I have not taken it.
1 week, okay. Yes.
Hello, please.
I know, pleasure.
Yes.
Please, Your Lordship.
Yes.
I beg to mention item 12. On behalf of respondent both 4 to 8, Your Lordship.
Who's for the petitioner? You inform them?
I couldn't find them in the court, Lordship.
You inform them?
Yes, Lordship.
I don't mention what informing is. 2 weeks, yes.
Lordship, similar prayer for item number 17. Lordship, we have received a affidavit in opposition filed by respondent, which is the reply to our rejoinder, Lordship. I'm praying for some time to obtain instruction.
2 weeks. Yes.
Number 16, my Lord.
16.
My Lord. Mr. Chanda is on the other side. I've
Mr.
informed.
Kanta?
Chanda. Mr. M. Chanda.
Where was the Chanda?
He's there online. I've informed him yesterday.
Yes. 2 weeks. Okay. Yes. Yes.
Deeply.
Lordship, I beg to mention item 15.
Number?
15, Lordship. If this matter may kindly be taken up after 2
You,
weeks.
you inform the other side?
My Lord, I appear for the state respondents, Madam.
Okay. 2 weeks, yes. Yes, quick.
May I please, Lordship? I beg to mention item number 13.
Number?
Item number 13, Lordship.
Only Modoc.
Yes, Lordship.
Why on behalf of petitioner?
Yes, Lordship.
Why are you mentioning it? No urgency.
Yes, Lordship.
Mr. Sheikh not ready.
No objection, Your Lordship.
Okay, 2 weeks. Okay. Yes.
Any order, Lordship.
May I please, Your Lordship?
Yes.
I beg to mention item 9 of the hearing list.
No objection.
After 2 weeks, Your Lordship.
Ruthi Chungaonam.
Yes, Your Lordship.
What's the matter about? 22?
Your Lordship, it's invalid pension, Your Lordship.
We are arguing counsel.
Mr. V. Kumar is the arguing counsel, Lordship.
2 weeks. Yes.
Yes, obliged, Your Lordship. Supplementary list, item number 1.
The petition is
What is this?
with regard to your Lordship's judgment. Your Lordship had delivered the judgment on 7th of June, setting aside the contract, award of contract. Now, still thereafter, my Lord, we submitted representations before the authorities, requiring them to stop construction or to do whatever they deem fit. Nothing has been done, my Lord, and the construction is still being carried on.
It's being carried on.
Yes, my Lord, we have also enclosed the photographs, my Lord. Your Lordship will find at page 44.
Page?
44. The camp is still there.
There is no labourers.
Well, the camp is there, and the machineries are also there. Page 45, your Lordship, machineries. And our representations, in our representations also, we have specified it to them. Your Lordship can find it at page 37. We communicated the order and we also required them to give us information as to what they have done subsequent to passing of the judgment. Nothing has been done in that regard.
Yes, I must scold you. What about this matter? You have any idea?
My lord,
Who appeared in the main case that time?
my lord, I believe Mr. Kharwanlang must be there in this matter. Kharwanlang and Mr. Pandey. Mr. Pandey and Kharwanlang, A.H. Kharwanlang.
Where's the order that was passed by this court?
Your Lordship's order is at page 21, apparative part is at page 33.
No. Where's the order, the title? The order of counsel that appeared there.
Oh, that order, your page 21.
Oh, yes. Heard Mr. S. Datta. There's a contempt.
Yes, my lord.
Issue notice returnable in 2 weeks. Yes, steps to be taken by said AD as well as by personal service within 3 days, just after 10 days. Yes.
My lord, can I submit for a fixed date?
Yes.
On 11th of July?
10 days, yes. 11 July.
Obviously.
Item number 2.
Please, Your Lordship. Lord, service is complete on the respondents. This is that matter, my lords, where we pointed out that there was a tender and hearing subsistence of the earlier tender.
Before my senior starts, my lord, I'm just praying that if this matter can be taken up at the end of the board, my lord. Mr. Pandey is having some difficulty in connecting, my lord.
Okay.
Item number 3.
May I please, Your Lordship? Lordship, in this matter, I am appearing on behalf of Dr. Pooja Agarwal for respondent number 3, UGC. Lordship, we need...
Please, this is a supplementary list. This is not the main list. Let the main list be called out, yes. This is a different list, yes.
Your Lordship.
Yes.
My lord, I have the instructions, my lord. My lord, this is a little complicated. What happened, my lord? Some posts are vacant, but those are. But here, my lord, the petitioner was a candidate was selected under unreserved category, my lord.
Yes. Unreserved.
Unreserved, my lord. Though she belongs to ST category, my lord, but she was selected in the unreserved category in the earlier selection process. Now, those 2 posts, my lord, the selected candidate joined the posts and subsequently resigned, my lord. So what happened subsequently, those 2 posts and some more posts were sanctioned, my lord. They were clubbed together and re-advertised, my lord. In the next selection process, she was not selected. She didn't feature in the merit list, my lord. Now she is come before your lordship, my lord. My lord, now what has happened, because she was a candidate selected under unreserved category at that point of time. Now the posts which are vacant with us, my lord, are 2 posts are vacant in unreserved category also, my lord. But the difficulty is, one is reserved for promotion, well, it is a promotional post. One is for PWD category, and 2 posts of ST category are still vacant, my lord.
No, that makes no sense. If 2 unreserved posts were there,
my lord,
selection was held,
my lord,
these people joined.
The selected candidates 1 and 2 joined, my lord.
They joined but
They
resigned.
didn't push the.
They resigned, my
They
lord.
resigned.
My lord.
Then it's natural that if
Yeah,
the waiting
yes.
list is there, that when they should be accommodated
They should have
against
been
that, those vacancies.
On top of that, Your Lordship.
Wait.
My lord, but what happened, my lord? The posts were re-advertised, my lord.
Why is re-advertised and by the time when the waiting list was selected?
And the petitioner participated in the next round of
Doesn't
selection
matter.
process,
not
my lord.
aware.
So, my lord,
Now you're saying that, okay, fine. In the next round selection, those 2 posts were taken out in spite of the waiting list. Waiting list was there.
Yes, Your
The
Lordship.
number 1 waiting list.
Yes.
Then that means the decision making process is wrong. Like by taking out those 2 posts, re-advertising them.
and moreover,
When
my
there
lord,
were candidates available
Your
from the
Lordship.
list.
Your
my lord,
Lordship.
there's another
moreover-
aspect. I can
Yes,
just-
let
just
them
to
complete. Yes.
place the facts correctly.
Yes.
She is number 2 in the waiting list also, my lord. The number 1 is not approached this honorable court. So that is one aspect of the matter, my lord. If lordship directs also, your lordship have to deal with that aspect also, my lord.
Yes.
Since he has not come, then the first selected candidate, my lord. So he waives the right or whatever, my lord. That is one aspect of the matter, my lord. A second aspect is, my lord, against the unreserved posts which are vacant, one is for promotional post
and the other one is reserved
This
PW.
additional post to the ones that she applied for first round. The selection was which post? The first unreserved post, the first round of selection was it?
My lord, earlier there were only 2 vacancies, my lord.
Right.
And both were under the roster system were unreserved, my lord. So accordingly they are advertised.
Right.
That's what happened. Because 2 candidates they joined and resigned, my lord, and in the meantime some more posts were sanctioned, my lord.
Right, understood.
So we clubbed together and re-advertised, my lord.
Why now PWD and one? Fine, then those were different posts, PWD and for promotion. This other 2 posts should be clear. How can you turn an unreserved post, which is an open vacancy, into a promotional post then? What was the term of the first advertisement?
No, my lord. When the advertisement, second advertisement was issued, I'll just place that, my lord.
Where's the second advertisement?
Second advertisement, कितना post किसका है? Unreserved कितना है? Reserved कितना है?
Page number 46 of the writ petition.
Page 46 writ petition.
For LDA, Your Lordship, it is at page number.
LDA post.
Page number 51, Your Lordship, serial mark as number 24.
It's the re-advertisement.
My lord, so
This is
4
a-
unreserved posts, 5 ST and 1 EWS, my lord.
See, okay, fine. Lower division clerk, 10 posts.
My lord.
4 unreserved, 5 ST, and 1
Economically
weaker
weaker
section.
section. Yes.
Then where is that? Where are you coming from the PWD and promotional posts?
But my lord, that is the situation right now, my lord.
I mean, these other people have joined.
Other people have joined, my lord.
Then there's something wrong.
Your Lordship, I would just like to.
And also the order of this court.
Those are
For
interim
the
order.
joining of the other people, that one post became vacant and that was not adhered to by the Negrims. So that is also. And you've twisted the selection because if 2 unreserved posts were there and she was on the waiting list, there was no question of reapplying those posts, till that so and so time has elapsed.
My
Where's the first
lord,
advertisement?
may I pray the matter comes at the end of the board, my lord.
Otherwise there'll be.
My lord, we also want to settle it, my lord.
consequences.
We also want to settle
Who
it.
was responsible for the decision? That in spite of court's order said keep a post vacant, went ahead and accommodated these people.
Well, actually, what happened, there was a miscommunication, and the posts were already, the appointment orders were issued before the orders passed by, lord.
No, Your Lordship, that is not a fact. Appointment order was given on the 8th of March. The court order was on the 23rd of February.
Well, you have to rewind the process. Otherwise, the entire selection will be set aside. Let those other people come to court also, those been selected. And let Negrams be held
My lord,
responsible.
I pray the matter come to the end of the board.
You can't
As a
play
last item,
around.
my lord.
If, in terms of selection with public employment, this is done, depriving people, and then in spite of orders of the court that the matter is seized, and then appointing people to somehow take the cause of action, that is. We'll have to ask the director to appear personally. Who was the name of the director?
Mr. Kohli.
Mr.
Professor Kohli. Mehta, Professor Mehta.
Yes, we'll have to explain actions to the court. We don't want to call anybody, but in this kind of situation, might be compelled.
But we also want to settle it, my lord. It comes as the last item, my lord.
Might be compelled to call him to explain the action.
But may not be necessary, my
Who
lord.
was the person responsible, in spite of orders of the court to issue the appointment orders? Yes.
Item number 4.
Doesn't matter. Well, it's, here your lordships have directed an affidavit from the respondent
Where's the
corporation.
affidavit? It's been filed.
It's been filed, my lords.
Today?
No, it was filed, my lords, earlier.
Yes, what did it say?
It's, there is no direct reply to whatever is the
Yes.
issue.
The counsel for the.
Well, it's the only thing, if I may just draw your lordship's attention to page 9 of this affidavit.
My lord, if I may interrupt again, Mr. Aditya Pandey is still having difficulty to connect, my lord.
Who was that on the screen then?
That's item number 5, my lords, some other matter.
4 and 6, my lord, of the supplementary list, and 2, my lord.
End of the board.
Item number 5. Milords, I filed one IA, Milords, pursuant to order dated 6th of February 24, Milords. My Lords, I disposed of writ petition as settled between the parties.
Yes.
The counsel for petitioner and respondent both made a submission that matter has been settled out of court, Milords.
Yes.
Milords, now my client says that he was not aware whether the matter was listed on 6th of February or not, and he has not imparted with any instructions regarding settlement of matter outside the court.
You see one thing, Mr. Abhishek, where you located?
Milords, in Delhi.
Yes. This order this court passes orders because the impugned orders have stood withdrawn by the respondents. Nothing remained for consideration. I don't understand what kind of instructions you're under. Because
Milords,
I come in case.
Milords, my only submission is that, Milords, this order has been obtained by connivance between both parties.
What connivance you talking about? Go to the bar council. Dismissed.
Milords,
my Lord, very strongly worded the application is filed on the without any basis, my Lord.
What?
My Lord, kindly see the prayer. My Lord, kindly see the prayer.
Are you aware of these communications at 11 January 2024? And is your client aware 22nd November 23 and 1823, whereby these orders, the impugned orders have been withdrawn by the respondents, and the matter stood resolved.
Milords, there is not only this impugned order. What they have done is, Milords, during the pendency of this raid, despite of knowing my condition, Milords, they have passed my transfer order also, Milords. In my transfer order, Milords, I have.
Who was the local counsel?
Pardon, Milords?
Who was the local counsel?
Milords,
my Lord, kindly draw contempt against using the language, my Lord, in the application. My Lord, what was impugned, my Lord, in the writ petition was withdrawn.
You file affidavit, and if we'll draw contempt, we'll draw contempt against the petitioner also. Yes, what application is this? Miss case number 111/2024. This is an application for recall of order dated what?
6th of February 24.
Otherwise, it's a time barred, my Lord.
Doesn't matter, 6 to 2024, on the ground that the writ petitioner had not instructed the counsel to concede the matter. Stop. Issue notice, Mr. Dr. M. Mozika also is present on behalf of the respondents, all of them.
My Lord.
Yes, after the file, yes, within 2 weeks, less thereafter. We'll hear it, and if costs will be imposed, we'll impose. If the writ petitioner somehow misled you and this court, then consequences will follow.
Milords, what has happened
you take proper instructions. Yes.
Daily list item number 1.
Yes. Where's affidavit?
May I please, Your Lordship? I am seeking apology for not filing yesterday, Your Lordship. It was not in proper form. They have sent it, yes, Your Lordship. See, Your Lordship, kindly have a look, because everything is received. Only yesterday, and I have sent for only 2 weeks time, maybe, when, Your Lordship. Because in the meantime, I'll try to file it by Monday or Tuesday if I get it, because I have already corrected it and sent it for the signature of Deputy Commissioner, Your Lordship.
As Bhattacharya submits the due to, on a variety of circumstances, could be filed today. Yes. Just a matter of 2 weeks. Yes. MSK Fukan appearance on behalf of respondents 1, 2, 3. Yes.
Much obliged.
Item number 2.
Yes.
Your Lordship, I have received actually.
You filed rejoinder?
Rejoinder, yeah.
You filed? You don't want to file?
No.
No.
Only yesterday I received actually from respondent number 3 this affidavit. Yes.
You want to file rejoinder or not?
No, not.
No. List was for hearing then. Party, Mr. So submits that no rejoinder will be necessary to if it's filed by the respondents. So this is a matter for hearing the usual course and so on.
High look.
Item number 3.
Please, Your Lordship. Lordship, I'm appearing for respondent number 3 on behalf of Dr. Pooja Agarwal. We need 2 weeks of time to file affidavit in opposition.
What's the matter about that?
It is more than 3 months, Your Lordship. They have
3
not
months?
yet filed. Yeah. So,
respondent number 3
1
is
week time may be granted.
UGC, Your Lordship.
Number 3 is?
UGC.
You have filed affidavit?
I'll be filing it today, Your Lordship, on behalf of respondent number 4 and 5.
4 and 5. What about the union? Yes, MSS Shalam, on behalf of respondents 4 and 5, submits that the affidavit filed the course of the day. What's the name of this lawyer? So and so, Vice P. Agarwal, praise funds allowed 1 week's time to file affidavit. Yes, just thereafter.
Obliged. Much obliged, Your Lordship.
Item number 4.
May please, Your Lordship. Your Lordship, I'm praying for some more time, Your Lordship, for the state. Respondent 1 to 4, Your Lordship.
Madam, I'm for 5, 6, and 7. I also request some more time. Madam, on the last occasion, on the appended appeals.
Yes?
Yes, Your Lordship.
Any objection?
No, Your Lordship.
No, yes. Respondents pray for allowed for 2 weeks' time to file affidavit. Just thereafter. And so,
Obliged, Your Lordship.
Item number 5.
You file the affidavit.
May please, Your Lordship. I am appearing for a petitioner, my lord.
yes. Have you received the affidavit?
No, my lord.
They have filed it, they said?
File affidavit, no?
No, sir.
Not been filed.
Oh, sorry, my lord. There was some defect. It could not be filed, my lord.
Yes, Dr. M. Mozika submits itself due to some defects. The affidavit could not get filed. He prays for about 1 week's time.
Well.
Yes, just after.
Obliged, Your Lordship. Obliged, Your Lordship.
Item number 6.
Lordship, conducting counsel, Mr. S. Marpan is on his leg, Your Lordship. He prays that the matter be placed at the end of the board.
Number 6 is what?
They file an application for deletion of certain names and addition of certain names.
What's the
Your Lordship, that's what he has.
where's the miss case?
That's miss case 99.
Yes. Who's first one number 4?
It's well, it's senior.
You got a copy of the application?
We'll file the affidavit.
You're objecting to deletion?
Yes.
Number 5. Why are you objecting to it?
My lord,
If he's dead, then why are you objecting?
My lord, superior order of the Supreme Court. It's in regard to substitution.
Yes.
Whereas they come with the issue of impleadment and striking off parties. So these two different rules, these two questions are totally covered by different rules, my lord. Substitution in the place of the dead person. Whereas impleadment,
These people they don't substitute. That's one number 5.
Pardon, my lord?
They're not being.
Not
These 7 respondents are not successors in interest as respondent number 5. Are they or not? Are they successors in interest
They are
of
not.
the deceased? They are not.
The parties in the application.
No. What is court asking? Now respondent number 5 is deceased. Correct. Now this application has defined for strike deleting the name of number 5 and for impleading 7 respondents in his place. Now the 7 respondents, you say they're not substituting him.
They are not related with the deceased.
Was not related.
Not related. The Kenyi, there are women as well, females as well, to be impeded. Whereas respondent number 5 is the Kenyi, the uncle. So their status is totally different, my lord. They cannot be impeded.
Well, okay, we'll delete. Then you file a proper application pleading the 7 respondents.
Your Lordship, let the matter, because this is being conducted by Mr. Marpan, let the matter be come up at the end of the board, Your Lordship.
And my
If
lord,
that's correct, if they're not successors in interest of respondent number 5 and not stepping to his shoes, then they have to file a proper application for pleading them as additional parties, if they're necessary or proper parties.
7.
Wait for a while. Yes.
But here we have taken steps, yet to receive instructions.
Steps for what?
But we have sent the copy of the writ petition to the government.
That's not acceptable. Steps now it's all electronically. What about service?
Yes, Lordship, I haven't received the report, Lordship.
You haven't received?
Yes, Lordship. Kindly give me one
Yes.
time.
Interference for respondent number 6 and 7, Your Lordship.
What about 5? Who's 5?
School Managing Committee.
So have you obtained status of service on 5?
Yes, Lordship.
Had he been served?
Yeah, I have taken steps, Lordship.
No, had he been served or not?
Yeah, I cannot serve Lordship because they are from the Garohes, Lordship.
You cannot say means status. Have you obtained the status of service from the post office?
Yes, Lordship, I haven't
You
received
obtained?
it. Yes, not yet received, Lordship.
Then say that.
Yes,
Yes, MS N. Raji, today under appearance on behalf of respondents number 6 and 7. With regard to respondent number 5, Mr. Ellen Areng submits that status of service has not been received. You want time for affidavit?
Yes, Your Lordship.
MS N. Raji prays for also Mr.
Capable.
How long?
Lord, I'll pray for 3 weeks.
2 weeks time for affidavit. Praise allowed. Just after 2 weeks for affidavit and for report of service on respondent number
5.
5, yes.
Much obliged, Lordship.
Item number 8.
My Lord, we have taken steps to serve a notice on the newly impleaded party, respondent number 8, my Lord.
Number 8 is?
Is the...
One
Yes, my Lord.
Anyone appearing on his behalf?
I'm appearing on behalf of respondent number 7.
7 is the managing committee.
I pray for 2 weeks' time.
You're entering appearance today?
Yes.
What is your name?
S. Milliam.
Louder, please.
S. Milliam.
S. Milliam. MS S. Milliam has entered appearance today on behalf of respondent number 7. Stop.
For the state, Your Lordship, 126.
Not filing affidavit.
We're filing, Your Lordship. I'm praying for some time, Your Lordship.
This report of service on respondent number 8 is still not yet received. Stop. Next para MS Isling for respondents number
126, Your Lordship.
126 and S. Milliam for 7. Pray for allowed 2 weeks time to file affidavit. At least a matter of 2 weeks for affidavits and for service report on respondent number 8.
Obliged.
Obliged, Lordship.
Hearing. Supplementary list. Second call. Excuse me. Second call.
No, wait, Mr. Raruta. This number, just before that, Dr.
number
Musika
2.
will pass orders. Then in Mr. Daruta's case, I don't think any further hearing is required.
There was 1 or 2 small submissions.
Enough of small submissions. Okay, you wait, then make a small submission. But you know what order's coming. Yes. Yes.
Second call. Item number 1. Supplementary list. Item number 2.
Your Lordship, if you may take up the matter after some time.
No, this is where's Mr. Paul? Yes, this is not the matter here. Yes, Mr. Pandey is ready.
Yes, my Lord.
Yes.
Lordship, this matter pertains to tender, Lordship. On 10/3/2023.
On
10/3/2023, a tender was floated, Lordship.
10/3.
Lordship. The NIT, Lordship, the NIT is at page 18, Lordship. If I may read the NIT, Lordship.
At page
18, Lordship.
1/8.
Lordship. This is dated 10 March 23. Meghalaya Power Transmission Corporation Limited is inviting tender for interested eligible bidders for construction of 132 kV transmission line with HTLS. Lordship, I may be allowed. Lordship, I see it.
Take the matter. We'll take assistance. Oh, he is submitting. Yes. Okay, yes.
Well, it's what we
page 18.
Well, this was the scope of the work originally, Malaj.
132 transmission line with
132 kVA transmission line with HTLS conductor along with 132 kV base and implementation of SAS and related services at 132 kV grid substation Nongol Vibra. Well, this is the scope of the work, and what I pointed out to your lordships is
yes. The last time I recall, you said they split the tender.
Malaj. Now,
After you
the
awarded
scope of work is clear from here, Malaj. If your lordships kindly have page 38.
1 second. Page 38.
38, my lords.
Yes.
This is the work, my lords.
Number 1.
My lords, at serial number 1, if your lordships kindly have a look, my lords.
Yes.
Construction, supply, erection, testing and commissioning of 132 kVA double circuit line with HTLS from 220 to 132 kV substation Nongal Bibra ISTS to 132 kVA substation Nongal Bibra MEPTCL.
Okay.
Now this was the work, my lords. And the present work which is there before your lordship is what we've assailed. Page. At page 607, if my lords have it. No, 608. Annexure 14.
Yes.
My lords, it is construction of 132 kVA DC line for upcoming 220 132 kV Nongal Bibra ISTS substation to existing 132 kV Nongal Bibra MEPTCL substation with HTLS conductor.
Okay.
Now, this first tender, which I pointed out at page 38, my lords, this was a comprehensive tender. It had, my lords, not only this work, it had other allied works also.
Yes.
Now, what we pointed out, my lords, is the tender is still subsisting at Annexure 3, page 586, if my lords kindly have a look, my lords.
But one thing, has the work been awarded? This work been
No, my
awarded?
lords, I was found as the lowest tenderer, L1, but till today they have not finalized the work.
Okay. I mean, okay. Is that a question of you being finalized with those?
My lords.
Or with the committee?
At page 606, my lords.
So where's that annexion?
My lords. At page 606, my lords, that I am declared as L1. Lordships, the chief engineer further informed the approval for the opening of the price bids of the qualified bidders and was received from the competent authority. The qualified bidders are as follows. My lords, I am at serial number 1, Ozone Engineers. And my rates, my lords, your lordships, in the table down below, your lordships would find at 1, 2, 3, 4, 5. Yes, my lords. I am at 44 crores, one is at 46 and one is at 47 crores.
Okay. Okay.
Now, if I may just take your lordships to Annexure 15 at page 609. This is that tender, my lords, the status of the present tender as would emanate from the website of the respondent corporation, my lords. And we've taken this on the 20th of June 2024, the day the writ petition was filed before your lordships.
Yes.
So, while this tender is, my lords, yet to be finalized, they would be at liberty, my lords, if they want to cancel the tender, that's beside the point. But in respect of the same work, now, at page 608, Annexure 14.
Yes.
My lords, a new tender has been called. Now, this says, my lords,
your contention is that this
is part of that original tender.
Is part of the
original tender.
And they've split the tender into a smaller proportion.
Lordships. And, my lords, I had pointed out also their own office guidelines, which is that your lordships would find at Annexure 13, page 607.
Delegation of financial powers.
My lords. So, the Director of Corporate Affairs, my lords, has issued a specific direction that tenders are not to be split.
Now, how is the tender split? We're not this was not technically equipped.
My lords, it is
discern,
other.
Whether it's
My lords, it is otherwise apparent. If your lordships kindly see the scope of the work again, it says construction of 132 kV DC line for upcoming 220, 132.
Upcoming 2020, 132.
My lords, because unless this, in this tender, if your lordships would have seen page 38,
Yes.
it is that same work, my lords, which is there. From, it is the 220, 132 kV substation, my lords, the line, double circuit line, which HTLS, from Nongal Bibra ISTS to Nongal Bibra MEPTCL substation.
Upcoming might be your line then. What
No, no, in that event, my lords, I would have no cause to come before your lordships, because then the work would have been already executed. This is my limited case before your
Mr.
lordships.
Pandey. Switch on your microphone.
I apologize, Milords. Milords, as the instructions, the oral instructions that I have received in respect of this matter is, Milords, that apparently, Milords, what had happened is that after this, Milords, opening of the bids, a decision was taken by the corporation to withdraw the tender because of the financial constraints. Earlier, the corporation was expecting certain funds to be released by the state government, but that did not happen. And they took a financial decision, and from 42 crores of the initial tender, the subsequent tender is only for a small part of it, which amounts to around 6 crores. And the remaining part the corporation is taking up on its own. So there is no question of splitting up. It's a question of financial prudence that they have taken, that they have decided to complete the remaining parts apart from the erection aspect. Earlier, Milords had seen at page 38, it is a turnkey project. At page 38, if Milords sees, which was pointed by my learned senior, Milords, 38 is construction, supply, erection, testing, and commissioning. 38, Milords, the first point at 38.
Where is the turnkey?
Correct. Milords, it says at the start of the project
page 18,
document itself. At
page 18.
Page 19, I believe. 19, Milords.
Okay.
Construction of so and so on turnkey basis.
Okay.
So from turnkey basis, in turnkey, Milords, everything is included. It has been reduced only to aspect of erection, Milords, of the transmission line, and remaining parts will be taken.
If that's the case, Mr. Paul, I think court interference is.
No, my lords, I'm okay if my learned friend is saying that, but in that event.
If they have every right to,
No, my lords,
to cancel.
In that event, my lords, the tender has to be withdrawn. What I'm submitting before your lordships is on the date on which we file the writ petition, my lords, which is after that day.
You file affidavit. Let them file affidavit. For Mr. K. Paul, learned senior counsel, for the petitioner, issued notice. Mr. S. Pandey, Mr. A. S. Pandey, with MSR only present, except with the all the respondents, to foreigners call for. Just a matter of 2 weeks for affidavits.
My lords, let status quo as on today be maintained.
We don't on public projects, Mr.
My lords, it's not a question. Your lordships, I am only on this issue.
On public projects, no status quo. We will, especially then the matters, we don't interfere. Only if there's, patent illegality and.
My lords, if I may, my lords.
In this case,
the tender which was issued in 2023, my lords, is valid, floated till today. Why I am praying for status quo is, my lords, that after filing an affidavit, they should not come before your lordships saying that post this order, my lords, they have withdrawn the tender.
No.
That would change the entire dynamics of my matter, my lords.
Item number 3.
To that limited extent, if your lordships can.
We can't tie their hands down, Suppose they're a corporation.
My lords, they cannot render my.
They don't have the withdrawal, they don't have the financial,
My lords, if your lordships would just bear with me for a minute.
2 weeks, Mr. Paul.
My lords, then may I pray your lordships, if they're going to file a short affidavit, let it be next week. This matter, so that, my lords, the matter does not become infructuous. I am only restricting.
File within 1 week, Mr. Pandey. Yes.
Because they don't deny the fact, my lords, that tender is alive.
What they say that no, they don't deny the fact that the tender exists. They don't deny the fact that, but the process is on this, and that's all. And so they decide to financial.
Therefore,
financial constraints.
No, in that event, my lords, my writ petition would have to be allowed, because once a tender is alive, my lords, without recalling that tender, I cannot advertise, my lords.
I have to recall the fresh tender.
That's what I'm submitting before your lordships. They admit, my lords, that the tender is alive.
The fact remains that you have not been settled with the work as yet. That's only.
My lords,
that's why we are at a threshold.
My lords.
That's why we don't know pass interim orders. Yes.
Next week, my lords.
Next week, I'll file
next week.
We'll
file, my lords.
Item number 3.
Yes, where's...
Again, my friend Mr. Pandey is here.
Yes.
Oh, I'm
Yes,
sorry.
please.
3. My apologies.
2 minutes. Yes.
4.
4. Yes.
Milods, we had filed an affidavit in this matter.
Yes.
Milods, this Milods is taking up item number
4.
6.
4.
4 and 6.
4 and 6 are connected
4
matters.
and-
Well, the issue is...
Yes.
1 4.
Issue is somewhat similar, Milods. In this matter, Milods, as far as the matter concerning Meghalaya Steels is concerned, Milods just kindly has the prayer which has been sought in this matter at page 11. I apologize, just
11 or 12?
Page
No,
12,
no,
Malad. It starts from page 12. Operative
12.
portion is at page 13.
Yes.
I apologize. Milods, the prayer is concerning to show cause as to why a writ in the nature of mandamus may not be issued, directing respondents to forthwith withdraw the impugned electricity bill dated 25/2024 issued by the respondent corporation, and further direct respondents not to levy any fixed charges for and during the period of temporary disconnection until the electricity is resumed in the plant, and thereafter setting aside the impugned electricity bill dated 25/2024. So, my lords, at the very first instance, my lords, this case concerns invocation of the writ jurisdiction, my lords, in respect of an electricity bill when they already have, under Regulation 4, my lords, an alternative remedy of going to the Consumer Grievance Redressal Forum, my lords. So, my lords, kindly in this regard, my lords, has the Regulation 4, my lords, which my friend is carrying, of the Meghalaya State MSERC Redressal of Grievance Regulations 2017.
Yes, regulation number
4, my lords, which provides for, my lords, grievance and their redressal.
One second.
This is, my lords, MSERC Commission redressal of
what copy is this?
grievance
Who
regulation.
gives the court copy?
My lord, this one. I'm apologizing. This one.
You give something that doesn't have
My lord, this is the
regulation
second
4.
one.
It goes from regulation 1 to regulation 6.
So, my lords, these are grievance redressal regulations. My lords, may directly have Regulation 4,
Yes.
which says a consumer who is aggrieved by the licensee not solving his grievances.
Grievances
may
mean
within
any
14
grievance.
days-
It'll mean any grievance.
Yes, my lord. My lords, grievances are enumerated in Regulation 5.
Voltage, fluctuation, erratic
And
supply, defective billing.
Defective billing, my lords. Defective billing. And, my lords, in this, so defective billing is something which is incorporated by the CGRF, CGRF's jurisdiction. And that could have been very well raised before the CGRF. And, my lords, there are in fact, my lords, the order itself has been passed by this honorable court at least on a couple of occasions, my lords. First is Annexure R1 of my reply as well, my lords, where a similar matter was referred to the CGRF. My lords, may just have Annexure R1.
Annexure R.
R1, my lords. Yes, my lords. At page 17.
Yes. Yes.
My lords, may I just see para 5 onwards, 5, my lords, at the outset,
Yes.
Mr. So-and-so, respondents fairly concedes that MSERC had no jurisdiction to entertain matters and pass orders thereon as has been occasioned in the instant cases. Para 6, on the submission of the learned counsel for the parties, these petitions are disposed of without contest, however, with the following observations. In Maharashtra Electricity Regulatory Commission versus Reliance Energy, it has been held that where state concerned had created a proper forum for redressal of grievances of consumers, the State Electricity Regulatory Commission had no jurisdiction to adjudicate upon such matters, and even Section 86(1)(f) of the Electricity Act, the said commission had no power to adjudicate upon disputes relating to grievances or of consumers, and it could only adjudicate upon disputes between licensees and generating companies. So, in that case, the case pertained to MSERC's jurisdiction, but it equally applies because it basically indicates towards existence of an alternative remedy for them in respect of defective billing. Milords, there is another order, Milords, that my friend is carrying. If she can also pass on that order, which had been passed by this honorable court, Milords. This is an order, Milords, passed in CMJ Breweries, dated 23rd of August 2022. And Milords just sees the prayers, because this will effectively also be applicable to the another connected matter. The first prayer says increase the load capacity, para 1.
Yes.
From 1000 kVA to 2000 kVA. The connected matter, Milords, concerns the increase in load capacity. And Milords, thereafter, there are various other grievances. And 3 is to waive off extra charges levied at double rate as penalty and delayed payment charges in respect of the power consumed in excess of 1000 kVA since 2015 pending various implementation. So levy of charges, Milords, is also included. And then para 2, Mr. K. Paul, so-and-so for the petitioner submits that the petitioner is constrained to approach this court by way of the instant writ petition by making aforesaid prayers in view of the fact that there has been no reply forthcoming of the representations. It is further submitted that in this regard, petitioner had approached the Meghalaya Consumer Grievances Redressal Forum and the said complaint had been registered and received on so-and-so. However, till date, they have not been afforded an opportunity, Milords. Para 4, Milords, then, without dwelling into other aspects, it would suffice at this stage, and the purpose will be served if Meghalaya Consumer Grievances Redressal Forum is directed to dispose of the application of the petitioner under Regulation 4.2 of the Meghalaya State Electricity Regulatory Commission Redressal of Grievance Regulations 2007 expeditiously within a period of 2 weeks from the date of receipt of the copy of this order. So, Milords, similar issues were thereafter referred to the CGRF, and my first submission is that as far as these two petitions is concerned, Milords, there is an effective remedy that is available to them, and that may be availed by them. Milords, that is submission number 1, Milords. Second, Milords, what had happened in this matter, Milords, is that this is a case of temporary disconnection, and Milords sees in this regard page 17
of the
writ petition. Yes, Milords.
Yes.
Milords,
Yes.
This is a letter by the writ petitioner. Milords, subject is temporary disconnection of electricity from 1st March for so-and-so. Dear sir, we are a steel manufacturing company based in Birmingham. We have been a good consumer of the company so-and-so. Second paragraph, sir, we have to undergo major maintenance work in our plant for which we are forced to keep our plant shut for at least 3 to 4 months time to undergo these changes. Sir, we request you to kindly allow us a temporary disconnection for 4 months so that our unit is not burdened with the minimum demand charges. Sir, our industry is going through losses, and it would be grateful of you if you can consider the request. So that is the request, my lords, made to us. And thereafter, my lords, this request has been decided at page 19.
Yes. 18.
18, my lords.
Yes. Yes.
With reference to the above, Meghalaya Steel so-and-so, my lords, is allowed for temporary disconnection. My lords, this is a letter which enumerates the conditions, my lords, which are to be satisfied by the writ petitioner for the allowance of
disconnection.
Yes, my lords. Yes, my lords. And in this regard, my lords, these are the conditions, and it would be better, my lords, if my lords sees it from the regulation itself. That is regulation 6.6. My lords, the first document which my friend had passed on to your lordships.
Taking it back, yes.
Yes. If
yes. 6.
my lords, just see 6.6. 6.6.
Yes, disconnection. Yes.
This, my lords, is temporary disconnection. And, my lords, the conditions are enumerated herein, what has to be satisfied. Now, it says, my lords, first a consumer shall be required to make a written request as per prescribed format in Annexure 24 of this regulation to the office of the licensee if the consumer wishes to get his temporary disconnection in case of no occupancy or renovation up to a period of 6 months. So, my lords, first thing is a written request. Consumer shall also be liable to pay disconnection and reconnection charges. This is the second, my lords, condition to avail the temporary disconnection. B, my lords, is also very important in this case and in the connected matter. The consumer is to clear all outstanding as on the date of application, or special readings may be collected by the licensee and bills served and paid by the consumer. So, my lords, there is an obligation for them to first clear the outstanding dues, and thereafter only their request for temporary disconnection would be considered as per the regulations. And thereafter, my lords, sees point number C, the consumer is to apply for renewal prior to the expiry of the end date, and inspection is to be carried out prior to reconnection. And D, my lords, no charges will be levied during the period under temporary disconnection. So they want basically the benefit of D, that there should not be any fixed charges levied during the period of disconnection, but that is subject to, my lords, certain conditions which are mentioned in 6.6. Now, my lords, what happens in this case is that my lords sees now page 19 of the writ petition.
Yes.
My lords, it says
they're tying it up with the other matter. Yes, yes. What do you have to say?
Yes, my lords. Now in this is a representation by them to us after the rejection of the request of temporary disconnection, my lords. They write to us and say that with reference to the subject cited above, this is to inform you that with regard to the request of Meghalaya Steel so-and-so for temporary disconnection of electricity and your referral to clause 6.6 of the Meghalaya Electricity Supply Code 2018 by letter dated 4/3/24 reiterating clause 6.6, and then that is quoted, and they say is misplaced, as the entire matter regarding payment and tariff on which such payment is to be made is subject to MSCRC case number 19 of 2022 and is pending final adjudication before MSCRC. In this connection, it is to be pointed out that the Honorable High Court of Meghalaya passed a consent order dated 15/2/2024 directing that with regard to tariff collected by petitioner corporation MEPTCL and also special tariff paid by the respondent consumer herein, the same shall be subject to final adjudication by MSERC. In view of the categorical directions that to pass with consent of MEPTCL, your requiring of Meghalaya Steels Private Limited to make any further payment for allowing the request of temporary disconnection would not only be in breach of such direction but also be contemptuous act. And thereafter they say, it is therefore requested the request for temporary disconnection of power supply to Meghalaya Steels be allowed immediately without any further delay. So that request, is premised on the fact that there is some sort of a stay which has been granted by this honorable court in the order which was passed by consent. And secondly, what they do is that acting completely contrary to the regulations, they, on their own disconnect their electricity.
Not consumed electricity.
You've disconnected.
I have not consumed. There's no question of disconnection, Mills. Yes. Disconnection has to be affected by them. They are the distribution licensee. How can I disconnect?
Yes.
If I don't consume, it's a separate issue.
Yes, yes.
Yes. Mills, just may note para 8 of the writ petition in this regard. The petition, para 8 belongs at page 8.
Yes.
The petitioner states that since no response was forthcoming from the respondent corporation and the petitioner company had already started repair maintenance work, the petitioner company took it upon himself and disconnected the connection from his end on 21/3/2024. And so that there is no energy consumption and no loss of.
I'll come back to this paragraph.
Yes.
So, Milords, now the situation is.
It's taking the law into his own hands. Yes.
Yes, Milords. Milords, the situation is as per regulation.
Why as late as in when is this in last 30th May?
I'm sorry.
Why was it filed as late as the matter with the cause of action arose in March? Yes.
Yes, Milords.
Yes.
It is filed with some delay, Milords. And Milords, and now the situation is that as a corporation, we are bound by the MSERC regulations, which are not under challenge. These regulations demanded them to clear the outstanding dues and follow all the other conditions which are mentioned in Regulation 6.6 for seeking temporary disconnection. The regulations did not contemplate a situation where they will on their own disconnect the electricity and then seek for benefits of temporary disconnection. So, Milords, they have no right as such, Milords, for any relief under Article 226 because the regulation itself have not been complied in this case. Milords,
my friend has finished, Milords.
Yes.
That's the last point.
Yes.
That's the last point. Now, Milords, coming to the contention as far as the consent order is concerned, Milords.
Yes.
Milords will find the consent order which has been passed, Milords, at page number 21.
Yes.
Now, Milords, this order was in respect of an interim order passed by MSERC in respect of disconnection. And whether special charges, special tariff would be applicable or a general tariff would be applicable, Milords. And thereafter, after hearing the parties, Milords, for a considerable period of time, Milords, thereafter this order has been passed, Milords. And I may, Milords, take your lordship to para 1, which says that matters have been heard at length on many earlier occasions, but hearing could not be concluded. Today, after hearing at some length, the parties are in consensus that it would be expedient that these matters are sent back to the MSCRC for adjudication. Accordingly, with consent of the parties, these writ petitions are disposed of with a direction to MSCRC to decide the pending cases and applications on their own merit and in accordance with law. With regard to the tariff collected by the petitioner corporation and also the special tariff paid by the respondent consumer herein, the same shall be subject to the final adjudication by MSCRC. It is made clear that this court has not entered into or expressed its opinion on merit of these cases, leaving all questions of law and facts to be decided by MSCRC. The matters involving public revenue, these matters involving public revenue, it is expected that the same shall be expeditiously disposed of by MSCRC. And with these, my lords, para 5, the writ petitions on direction as contained above are hereby closed and disposed of. So, my lords, here is a disposal with the consent of the parties, which now govern the rights of the parties. And there is no stay, my lords, as far as this order is concerned. And today, the writ petitioner, my lords, is trying to mount a collateral attack on this order. My lords, as far as my lords, Order 23, Rule 3, capital A is concerned, my lords, has Order 23, Rule 3 of the CPC, my lords, there the consent order cannot be challenged by way of a fresh petition, my lords. Today, if my lords,
I'm asking for implementation of that order, my lords. I don't know how my friend is saying I'm challenging this order.
Yes. My lords, it is in fact, because it is in fact, my lords, it's a challenge because, my lords, today the petitioner is trying to read into this order and find out a stay of the outstanding areas which has to be paid. So any order, if passed in the writ petition, would amount to modification of this order, my lords, which would be an abuse of process of law, which would be, my lords, not permissible.
Yeah.
So, my lords, that is there, my lords, that has to be taken into consideration, my lords. And with this, my lords, I would, my lords, just summarize the 3 points that I have made, my lords. First is in respect
under Regulation 4.2,
yes.
Then 6.6 is the conditions for disconnection. That's it, and then they have disconnected themselves, and then that's it. Yes.
And then will also no challenge to a consent order by a fresh petition.
I don't think they're taking yes, shelter of it. In fact, to say since the matter is still seized by the tariff payable by them has not been. Anyway, yes.
This limited issue, as your lordships have rightly found out, is the only issue why this petition is before your lordships.
Why can't you avail of alternative remedy?
My lords, because there is no question of alternative remedy in this case.
Why?
I simply tell them it's not a dispute regarding a bill per se, my lords. What happens is the sequence has been placed by my learned friend. We go before MSCRC, my lords. Matter comes before your lordships. Your lordships pass an order saying that. My lords, I'll just read the operative portion of that order. My friend has already read it. And it's a consent order, paragraph 3, page 22, my lords. It says, with regard to the tariff collected by the petitioner corporation, MEPDCL, and also the special tariff paid by the respondent consumer herein, the same shall be subject to the final adjudication by MSCRC. Now, what had happened is, my lords, this bill which they have generated of roughly about 10 crores is the differential amount between the normal tariff and the special tariff, over which we were fighting before your lordships, my lords. We came to a conclusion that MSCRC will decide whether I am required to pay the special tariff or the normal tariff. If they say normal tariff, my lords, I would have to pay the 10 crores. If it is special tariff, they would have to refund me roughly about 15 crores. That was the issue. So, my lords, we reached a consensus. We went back to the MSCRC. MSCRC seized of the matter.
What happened there?
Matters going on, my lords. There is a vacancy, so now the matter is not being heard. In the meantime, my lords, we had to take a regular maintenance. So we requested, my lords, please allow us disconnection. Now, taking shelter of 6.6, they come and tell us that you clear off the outstanding due. Now, this outstanding is which outstanding? It is not the current bill, my lords. Had it been the current bill, I am obligated to pay, I have to pay it. It is the differential amount. Now, once there is a differential amount, my lords, and your lordships have already passed a consent order, it is with the consent of both the parties, we come before your lordships that let it be decided by MSCRC, whichever way MSCRC will direct, my lords, we will
Now,
pay.
what about this bill in issue 6? Is this the bill that they've suddenly with?
My lords, this is that 10 crores which I'm talking about. This is the differential amount.
This is the amount it's demanding now.
Differential amount.
Is that correct, Mr. Pandey?
That is clear from their affidavit. I'll take your lordships to their affidavit. I was just trying to take your lordships to
what they're
Yes.
Just a second, my lords.
See the thing, let's make things clear. Now the thing is that they've come with request for disconnection. Now, as per 6.6,
Para 27 of
it
their
mandates
affidavit.
that you clear outstanding dues. Now, outstanding dues will be the outstanding dues which are still yet to be educated upon. Outstanding dues are current bills before the the disconnection.
Para 27 of their affidavit, my lords, may kindly have a look at it. What is this 10 crores?
Because
they've given a breakup.
Para 27.
My lords, page 9, para 27. If my lords have a look, that it is submitted that the bill raised on the petitioner also includes the pending dues to the tune of rupees 10 crores so and so.
Can you do one thing? Give us a last order from the MSCRC with regard to this dispute.
My lords.
Yes, we'll have it. Yes. Then we can pass orders. Because if then it is not justified, Mr. Pandey.
It's only on that limited issue, my lords. There's nothing else.
Just give the latest from the order sheet.
My lords.
Yes. Yes,
and insofar as the disconnection part is concerned, my lords, para 8 is not happily worded, but what they did is, my lords,
that also you have to.
No, my lords, that I'll just show, my lords.
For that also.
No, my lords, I'll just show that. I must clarify that. At page 24 is my email to them. My averment in para 8 is not happily worded, my lords. I must apologize for that. Para 24 is the email.
Yes.
That is, my lords, annexed to para 8. It says, my lords, this is a reminder to our letter dated so-and-so. Dear sir, we have stopped using electricity from 21st March. Hence, please consider our request for not charging fixed charge from so-and-so. Basically, my lords, the cutout which is there, my lords, the main switch, as we call it in normal parlance, is put down, my lords, because otherwise the maintenance work cannot happen. Basically, there's no consumption. That's it. I cannot disconnect, my lords.
Well, we go by pleadings.
I'm sorry.
We go by pleadings. That you have discovered by SL, yes. You just day after
tomorrow. Monday.
Monday, yes.
Monday.
This is a matter of Monday.
Monday.
Before the orders, yes. Meanwhile, Mr. K. Paul to produce the latest orders passed by MSRC in the matters referred to.
Well, it's the MSCRC. I'll just give the case number. Let's
give it to the court master.
I'll give the. Item 6 is similar. Same issue.
Item number 3.
Okay.
Yes, instructions you got. Where's the petitioner? Yes. About one more to pour. About the note to pour. Yes, Dr. Mozika. What are your instructions?
Well,
how do you untangle this mess?
Well, this is a bit complicated now.
How you
at our end also, Malad.
You have already vested other people, right? How do you untangle it?
Malad, our case was, Malad, initially.
We're not talking about your case. How do you untangle? You said come instructions how to untangle the mess. It's a mess.
It is a mess, Malad.
Yes.
Because
pass orders.
Because, Malad, what is most relevant from our point of view, Malad, that when the two candidates resigned, Malad, from the early selection process, Now the Supreme Court says, my lord, in such, once there is a resignation, my lord, the select list expires for all purposes. And the fresh advertisement has to be issued, my lord. So that is what we did, my lord. In the meantime, six posts.
Why does it say that?
My lord.
What are your recruitment rules with regard to, what happens at the meeting? You must be having some recruitment rules of your own. You don't have recruitment rules or executive instructions.
Well, the recruitment rules.
Must be having.
Recruitment rules doesn't cover this aspect, my lord. But we have referred to para 5 of our affidavit, my lord.
Para 5, your affidavit.
Sorry, my lord. Page 5, my lord. At para 11B.
Yes, page 5.
Para 11B.
Yes.
You said, my lord, the Honorable Supreme Court in Manoj Manu versus so-and-so has held that there are two situations. Situation A, where the candidates who had initially joined but subsequently resigned quit, thus resulting in creation of vacancies again. And situation B, where out of the recommended candidates, some candidates do not join at all. In situation A, when the selected candidate joins and subsequently resigns, the vacancy notified gets exhausted and the vacancies arising thereafter has to be filled up by fresh examination. Therefore, the Institute had advertised the fresh vacancies on 17/10/23 by the advertisement number so-and-so, so-and-so, so-and-so.
Which paragraph this is? Does this say that? The judgment?
Page 23. Para 9, judgment.
No, still not clear which. No, it's not clear at all. See, can we confer to reading folks that there's not a case where one person easily joined and therefore resigned, therefore promoted. Vacancies again. What does Negrams do in other matters? Such matter? Do you maintain a waiting list or not?
But here
this is a different situation.
The situation was slightly different here, my lord, because soon thereafter, my lord, a certain post was sanctioned. So
it's totally different. This is a totally different situation. So out there is different in the sense that what has happened is suppose they didn't join, then it lapses. There's a new recruitment. Here what you've done is that you've taken those two which are vacant and then you've clubbed them together with some other vacancies and issued a fresh advertisement.
Well, if we treat those two vacancies, my lord, as far as two vacancies are concerned, my lord, the people joined, my lord, and then they resigned.
Your Lordship, may I make a submission with regard to that contention? Your Lordship, kindly take to page number 21 of my rejoinder, Your Lordship. Page 21, which is Annexure 1, Your Lordship. Letter dated 9 November 2023, written by Negrams to the Under Secretary, Northeast Division, Ministry of Health and Family Welfare. Your Lordship, in this letter, they sought clarification whether appointment to waitlisted candidates should be given or not.
Yes.
And in this letter, Your Lordship, kindly turn to page, on the last paragraph, Your Lordship.
See, this goes to contradict your own submission, Mr. Dr. Mozika. See the second paragraph. You're saying you don't have any rules and executive instructions with regard to waitlisting.
And the reply is also that waitlisted candidate.
Paragraph of that letter. We stated the validity period prospective waitlisted candidates is 1 year from the date of meeting respect section committee. Hence, the validity period of 1 year of the respective would lapse on 22/3/24 for these posts.
Yes, Your Lordship. My case is for this 24.
Then where's the reply?
Reply is at page number 33, Your Lordship.
I'm afraid.
Here at point number 2, Your Lordship, for all posts, page number 33.
Yeah.
For all posts, Your Lordship.
Yes.
Vacancy should be filled up from the waitlisted candidate for all
This
posts.
are your instructions. You can't take shelter from court that you can easily distribute. Now, that's why the court asked one question. You have to put rules and set of instructions, and the instructions are very clear. It's from the Government of India.
And your Lordship.
The office memorandum which covers, my lord, that is at page 32 of our affidavit.
See, look at the direction. You're not supposed to do so and so.
It says, my lord, to follow the 13 June 2020, 13 June 2000 office memorandum, my lord. That your lordship will find it page 32 for affidavit.
Your Lordship, because when they rejected my my representation also, they quoted this office memorandum. That is why, Your Lordship, we filed RTI to know about the contents of this.
13 June 2000.
2000.
See, the 5th Central Pay Commission so-and-so has reviewed reduced delay in post vacancies resulting in resignation or death on government in 1 year upon should fill immediately by candidate from reserve panel. If a fresh panel is available by then.
If fresh panel is not available then.
Yes.
Here was
the fresh panel was not there.
Reserve panel is ready. You would be ready for full hearing, or we'll call your director also. Because I think he's in contempt of the orders of this court. What order was that dated? We might have to draw up some more.
That we have explained. Try to explain.
We might draw up some more because we can't. If that is the instruction, that means you have totally convoluted the system to your own advantage.
To that
in the sense
model,
that to cut out the people. If really is the in spite of the order saying keep one post vacant, no, you've appointed them to totally dilute the whole issue.
That was because of miscommunication on my part.
We'll have to drop some more too, I think.
That we have tried to explain in our affidavit also that how that happened.
You can't treat
another. Petitioner also
go behind your own.
Petitioner also never bothered to inform the department that there is some interim order.
Because at the time of the motion,
you can't, Dr. Muzika, go behind your own executive instructions, behind your own queries to the Ministry of Health with regard to various candidates, being fully alive to the situation that the waiting list is alive till so and so 24. In spite of that, re-advertise those posts which are there. In spite of the presence of office memorandum says that if there's no reserve list, then you like or a fresh list.
But in the meantime, there's a fresh list, my lord.
But then I think there might be trouble for your director if he's the person responsible. If not, with this, we'll see. We'll pass orders.
My lord, to that effect, my lord, as far as violation of interim order or non-compliance with that is concerned, my lord, the last candidate who has been appointed, my lord. Lordship directs will remove him appointed. That's not a problem, my lord.
There's a question of direction. He's got his own vested right also. Who's liable for all this mess? Who's liable for all of it? If you just followed your own office instructions, the own instructions received from Ministry of Health, Family Welfare, they would have the situation.
But the petitioner takes a chance, my lord, in the secondary proceeding.
I did not take a chance. It's not aware.
Depriving, public employment is not a question of is your own grandfather's property that you can give to anyone. They're very serious this matter. We'll take it up. This is a matter for hearing as a fixed matter on 12th of June.
12th July.
12th July, sorry. Or no, on 11th July.
Friday, 10th or 11th.
Okay. But then is before one. We will pass, if we're not contempt, we will pass some, the order will reflect something else.
Well, actually, what happened, Miss Rumtha was there. I was not available that day, and the interim order was passed in a missed case, my lord. That is where.
Your Lordship, and they've accepted notice on behalf of the respondent, so that is why I do not take further steps.
Whatever's code of record, whatever's on record, that will go.
Item number 6.
And your blood.
Yes. Where's the objector?
Please, Lordship.
No, where's the objector? The only objection, Mr. Marpan, is this. that you have deleted respondent number 5.
Yes, sir.
But the people you seem to impede to have no link with respondent number 5.
No connection with respondent. It's
Then
the
you have to file a separate
correspondent.
impleading application.
Because in the writ petition, there are letters and correspondent which I have enclosed in the writ petition.
No, then you have to file a special impleading application, not to replace him.
No, not replacing him.
Then we thought there's a substitution application.
My lord will just see para 2 of that application. What my friend has said, there's nobody to substitute, which means therefore that there are no legal heirs.
Where is that?
Can you see para 2 at page, in this case 99.
Mr. Marpan, if you come with a proper application for impleading them then.
I had filed this petition because on the submission made by the respondent number 4, that the respondent number 5 had passed away many years
You
ago.
see, you wrote an application seeking deletion of the name, thereafter to implead so and so. Court was under the impression that, that these people are stepping, they are the success interest of respondent number 5. But if there's no link, where does it go along?
Given reasons. I've given reasons in para number 3 why I'm asking the other to be impleaded.
So you file a proper application. We'll allow deletion.
For impleading then other.
Seeking deletion. In this case number 99, that's an application seeking deletion of the name of respondent number 5, who stated to have been since deceased. The application is not opposed to. The application is not opposed. This prayer is not opposed. The respondent number 5 stands deleted. Stop. However, with regard to the second part of the prayer, he said application for impleading certain other persons as part of the respondents, as it has been very submitted that they are not the successors in interest of the deleted respondent. Mr. S. Marpan prays for and allowed one return to bring in a proper application for impleadment. Yes, Ms. Kivaita stands disposed.
Pleasure.
See, you under the impression that they are coming, but then
no.
Yes.
Supplementary 1, item number 1.
Yes.
It is, Lordship. Lordship, here the petitioners are the residents and elders of Ratchabong. The Lordship is very much aware that Ratchabong consists of 12 villages. Now, there was a land acquisition proceedings initiated by the government for the widening of the road. So, a dispute arose. A clan calling themselves the OP number 2, the Laikpo, they claim that this portion of land belongs to them.
Yes.
And the then Sardar of Ratchabong also
Which
filed.
clan? The clan said it belongs to me.
Yes. Then the Sardar, the then Sardar, he also said no, this is a Raj land. It doesn't belong to anyone. So on that basis, it was referred to the Special Judicial Officer. Now, before the Special Judicial Officer, the earlier Sardar had filed a claim petition in his representative capacity, stating that this is a Raj land. No individual, no clan can claim right over it, and the beneficiaries of any money should be the people of the Raj. So that is on record, my lord. Now, what happened? The OP number 1 was elected as the new Sardar on 4/10/2023. This date is important, my lord. Now, on 28/11/2003,
when is elected on?
On 4/10/2023.
4/10.
Yes.
23.
Yes.
Where's that document?
No, that is not on record, my lord. But what is important is on 28/11/2023,
yes,
the present OP number 1,
yes,
page 33, my lord, we'll see, page 33.
Yes.
He unilaterally, enters into a compromise agreement with the clan. Now, my lord, 33, your lordship will see before the last paragraph, whereas the first party acknowledged that the land acquired belonged to the second party, and subsequently,
whereas
whereas the first party acknowledged, this Sardar has acknowledged that the land belongs to the second party, that is to the clan.
Yes.
And subsequently, the first party approached the second party to solve the matter amicably, and the second party has agreed to the same based on the following terms and conditions as stipulated hereunder. So, basically, the OP number 1, he entered into a compromise with the OP number 2. Now, without the knowledge of the people.
Now, who are you?
Now, we are the residents, elders.
How are you authorized?
We are not authorized, my lord. This is a right land. Any person can come forward, especially the elders. Now, one of the petitioners is also the Sardar of the, he had contested the elections. Anyway, the fact is that these 15 persons, they filed a petition to the SGO objecting to this compromise. They said the Sardar cannot enter into such a compromise without the knowledge and consent of the people of the Raj.
Yes.
My lord, will come to the order passed by the court below. Page 63, my lord. Before that, my lord. Now, on our application also, filed by us, now the show cause was filed by the OP number 1, that is by the Sardar, not by the clan also.
Your?
We had filed an application under 151 before the special judicial officer for stay of the making any payments.
Yes.
Now, the OP number 2, who is the clan, who is the Laikpo clan, they did not say anything, but the Sardar tried to justify that he has the authority, to enter into the compromise agreement.
Where the order of the special which is outside?
First order. My lord, first order was at page 35, my lord. First order was page 35.
Yes.
Now, CR put up before me, seen the application filed by Sardar Rajchabong, bringing on record the compromise agreement dated 22nd November 2023 between the claimant and OP number 1. The application is moved by Shri A.G. Moomin, Advocate. Learned counsel for the claimant Shri So-and-so and Shri S.S. Das are present and submit that they have received copy of the petition. Learned GP submits that the parties may be called and examined by the court. I agree with the submissions of the learned GP. Both parties are directed to appear before this court on the next date fixed. Fixed 18/12/2023 for examination of parties. Now, next page, Bala, 36. CR put up before me. Petitioner is present along with his counsel, Shri So-and-so. OP is present along with counsel, Shri So-and-so. The parties are examined. This court is satisfied that the parties have arrived at a compromise with regard to LA case number so-and-so. Hence, the compromise application is allowed and shall be read part and parcel of LA case number so-and-so. Application is allowed and disposed of. Now, then we filed the application. Now, my lord, before we come to that, my lord, once it is a representative suit, now the law is very clear. If there is any compromise, we have to seek the leave of the court. The court has to issue notice. Now, Order 23, Rule 3A is very clear on that. Although the SGO is not bound in view of Section 60 of the new Act, but then natural justice should be followed, my lord. No notices was issued. Now, we are not aware if he was impleaded also, this OP number
Now,
1.
what happened? Now, what is
Now,
the...
my lord.
Have you annexed the...
Yes. Now, my lord, we'll just come to page 69 of the impeached order.
This is the operative part.
Yes, just the operative part. '69, my lord, second paragraph. No show cause was filed by OP number 2. My lord has got the page.
Page 69.
69.
Yes. Who's OP number 2?
OP number 2 is the clan.
Okay.
OP number 2. No show cause was filed by the OP number 2. However, learned counsel Shri So-and-so submits that the applicants are not affected by the land acquisition. The learned counsel submits that he is under instructions that the OP number 2 is ready to give an undertaking that the amount received in this instant LA proceedings will be benefit for the and welfare of the residents of the area. Very strange, my lord. During the course of hearing, the applicant was asked if any lands of the applicants were included in the land that has been acquired. In response, the learned counsel submits that the land of the applicants are not included in the area in dispute. However, being residents of the Raj, they are of the opinion that any compensation paid to the Raj should be shared with the applicants and the clan members. Learned counsel for the opposite party, number 1, submits that the land that was acquired belongs to OP number 2. Now that this is the Sardar, who is the custodian of the lands in the area. After hearing the learned counsel for both sides, it becomes apparent that the applicant is in no manner affected by the acquisition, as no part of their land falls in the disputed land. Therefore, on the face of it, the objections raised by the applicants is not maintainable. Be that as it may, since the counsel for the OP number 2 states that whatever land compensation is received will be used for the welfare of the residents and is ready to give an undertaking, the OP shall file an undertaking on affidavit to this effect. Oh, look. OP number 2, on one hand, is claiming that he is the owner of the land. Now it makes a submission in court as if that, no, he's merely the custodian, and in fact admitting that this is a right land.
So where's the records of that, where they are trying to establish before the court that it is right land?
Well,
how far it proceeded before the court of the special judicial officer?
Well,
how far that matter proceeded? Where, so when this matter has come up and gone for reference, how far it proceeded? With, I mean, on
not yet. The evidence is not. So page 16, my lord, I have annexed the claim petition of the earlier Sardar. Page 16, my lord. Page 16. This is the claim petition filed by the Sardar. At page 17, para 5, my lord, will see.
Yes.
That in this instant claim petition, the claimant, being the traditional head of the Darbar of Raj Shabong, he represents the Darbar in particular and the Raj Shabong in general, and is entitled to receive the award in respect of the portions of land belonging to Darbar Raj Shabong, acquired by the government.
And where's the reply to this one? I mean, from the side of those.
I'm sorry, my lord, we have not annexed that copy.
The thing is that now you meet with the Sardar Raj Shabong party.
Yes.
Sardar Raj Shabong.
Now they're newly elected. We don't know whether.
Herin Singh Kongai.
Yes, yes. Now this
compromise was entered by whom?
By him. No. A compromise was entered by OP number 2, my lord. OP number 1 here in this petition. Respondent number 1, Hering Singh Kongai. Now the claim petition was filed by the then Sardar, whose name is Bigaston Lingdo, at page 28, my lord, we'll see.
Petitioner, the 4 petitioners.
Yes. In fact, before the trial court, 15 had gone, but because of there was no time, my lord. In fact, this was uploaded only day before yesterday.
No, but the composition not being released now. They've asked.
No, we have not. That's what we are just concerned about that.
It's not being released now.
Not released.
Something in the morning that I thought that now the check being signed.
It could have been released, my lord, as soon as he gives the undertaking. As soon as the undertaking, and how can the OP number?
But what is it? I mean, we have to first examine who are you.
Yes, we are the.
Where have you stated in your petition? Pardon me, this is Raj Shabong only.
Yes. My lord, our application before the lower court.
Yes. That is what, because
yes.
Where's the application for the one? Which page is that?
Page 37. Well, look,
now this
appreciate the fact that
proceedings of the compromise. How the compromise arrived at? Was this a darbar?
No.
There was a darbar empowering the Sardar to
no.
compromise.
In fact, that was done subsequently. When we filed, there was no darbar. There was no darbar. He did it by himself, my lord. And in fact, 1 month after he became the Sardar, and we don't know, my lord, whether he has been impleaded even in the LA case. Because LA case.
Yes, Archival Data, anything to say?
My lord, yes, this is a dispute between Jawar and Sardar, my lord, and the state is a formal party in this matter. And your lordship, this issue, because that issue has been settled on the basis of compromise, my lord, and compromise itself is in question. There is some substance in what.
And he's saying Order 23, Rule 3A.
Yes, if it's.
But it's order of consent.
No, my lord.
Between the claimant
no, my lord,
and
we'll see.
Because Sardar will represent the Darbar, and there is no consent by Darbar, my lord.
Yes.
That is what I could gather.
It has to be by the entire people because
And
you
we
are
heard
yes.
Mr. TP saying to our learned counsel for the petitioner issue notice, returnable in 2 weeks. Mr. General Advocate with our police present on behalf of point number 3, no forum is called for. Notice to issue to the respondent 1 and 2 within 3 days now. By registered AD or by and with personal service sub. List on so and so. In the meanwhile, the order dated. What is that? Where is that order? Impin order.
Impin order dated.
Dated
12/6. 12/6.
Dated 12/6. 2012. No.
12/6.
12/6/2024.
12/6/2024. Passed in civil misapplication number 33 within bracket capital H 2023 in LA case number 1 2021 shall be kept in abeyance till the next date.
Hearing supplementary 7.
Yes.
The lordships heard the matter in earlier occasions.
Pass. When's the order?
Yes.
Mr. Nasrullah?
24/4/2024.
Check the order 24/4.
2024.
Yes.
You have passed the order and I have agreed, and your lordship may kindly pass the formal order giving a time frame within which they will pay the amount. Otherwise, some will carry the interest, as may be directed by this honorable court.
I've seen this order, my lord. My lord, only 2-3 aspects on merit, my lord. My lord, our first submission is, my lord, that the betel nut that was seized, my lord, was unfit for human consumption.
Was not fit for human consumption.
Human consumption, and to that effect, we have a certificate from the food laboratory, my lord.
FSSAI.
My lord. My lord, I'll just point that out, my lord.
No, Dr. Moser, over and above that, you see, the only thing is that when the matter was heard and that order was passed, that it was, the seizure amount was, that was fixed, the amount fixed by you only on the date of seizure, the approximate amount, the cost, whatever the value of the seized produce. That's the only thing.
My lord, what happens, my lord, when seizure is done initially, my lord, so there's a tariff value given for every import or export commodity, my lord. Now, depending on the quality, because that was a very tentative view, my lord, taken at the time of intersection with the truck on the highway, my lord. So, my lord, that by no means can be the actual market value of the product, my lord. And to that effect, they themselves had offered to that the value may be taken as 80 rupees, something which I point out, my lord. So apart from that, my lord, once a betel nut has been certified as unfit for human consumption, my lord, now the manual of customs.
The value becomes zero.
Well, the customs manual says, my lord, if something is unfit for human consumption, it is incumbent upon the department not to recirculate it in the market. It should be destroyed, my lord. Now we simply followed that, my lord. My lord, page 18 of our affidavit, Lord, so kindly says the manual, customs manual.
Only one thing, Dr. Mosika, is that look, whatever it is, whether it was unfit or fit for human consumption, that's besides the point.
That is the already settled issue, my lord.
The central issue is that after adjudication, appeals, and so on, it was found that it was not smuggled. That's all. Based on the facts of the case. I'm not saying that,
My lord, to that one plausible reply which I may forward, my lord, at once, my lord, is that taking analogy from the NDPS cases, my lord. Even if the accused person is acquitted, my lord, that does not entail that the seized narcotics will be returned.
Narcotics is different. This is betel nut.
My lord, it comes to almost to that, my lord. If lots of kindly.
You can't. You suppose the person acquitted, he be given back heroin. Oh, that is absurd.
I request my learned friend not to revisit all these things.
Page 18 of
subtle fact.
Page 18 of the affidavit, lots of kindly. Page 18, only one or two must be.
He has enough argument on this. Same thing is repeating. They have repeated in Tribunal, High Court, Supreme Court, everywhere, my lord.
Where?
Page 18, my lord.
Of your first affidavit?
Of my affidavit, my lord. The affidavit of September 23. Page 17, this is the disposal manual of 2013 of the Customs Department, my lord. Now, Rule 8.11, destruction.
Rule
8.11.
8.11.
It says, my lord, the Commissioner have full powers to order destruction of goods of the following description. At clause C, my lord, foodstuffs, spices and other goods which are unfit for human consumption.
8 point?
Page 18, my lord.
Sorry, yes. Right. Commissioner have full powers to order destruction of goods of the following description: substandard drugs, time expired medicines, chemicals,
foodstuffs, spices and other goods which are
foodstuff, spice, other goods
unfit for human consumption.
Yes.
So, my lord, following this, my lord, we destroyed the betel nut, my lord, and the destruction certificate we have annexed, my lord.
Yes.
At page 15. In front of page 15, my lord.
15.
Certificate of disposal of betel nut.
Yes.
Disposed on 28, 29 and 30 at the departmental parking premises, Chandrapur, Guwahati. And
your seizure value is 2 crores 90 lakhs.
That is including of truck, I think. Or this is the...
Okay, yes.
It may be some other betel nut also.
Other betel nuts.
Dry betel nut 400. What is the 88,000 one? First one? Oh, first one, yes. Betel nut, dry, Guwahati, dry betel nut, quantity pack is 400. Yes.
So some other betel nut were also destroyed, my lord, in the same process. And now, my lord, our third submission is, my lord, that by destructing this, my lord, we have not derived any value, my lord.
Yes.
The department has not gained anything. Had it been a case of auctioning, my lord, if we derived any money, maybe this honourable court could have directed us to pay the money.
But they've lost money.
My lord, otherwise also this is unfit for human consumption, my lord. For example, even if we return that goods to them, my lord, being
they have got
unfit
no
for human consumption, there is no...
For food test, that was written in Tribunal order at page 98, High Court order at page 100 and Supreme Court order also. All this is approved.
And my lord, at page 43, they offered 96 rupees. They themselves valued it at 96 rupees.
That is offered when they are adamant that illegal food test, bogus food test. Then we have contracted plywood factory, 96, and that too also. That is a basic price. That is a basic price. Now we have to add this custom duty, redemption fine, and penalty. It will almost 3 times more. Then 96 into 3, 288.
You'll get your money.
14.
Much obliged.
Mr. Jha is not here, I think.
Mr. Jha, I think some cataract eye surgery.
A long time. I also had cataract surgery. I was out only for 3-4 days. Yes.
He was circulating photographs next day, my lord.
None appears for the petitioner. Just after 2 weeks. It's only as a counsel for the counsel for the petitioners on leave. Just a matter of 2 weeks. Yes.
18.
May I please, Your Lordship?
Yes.
Your Lordship, this matter is regarding the illegal appointment of the junior athletic coaches.
Of?
Junior athletic coaches.
You pull the microphone closer to you, yes.
This is regarding the illegal and biased appointment of the junior athletic coaches, Your Lordship.
Athletic coaches?
Yes, Your Lordship.
Yes. Yes.
Your Lordship, I only
All
have...
represented? Yes.
Lordship, the only points I want to make is like, even though it is a settled law, we are aware of it, that once a person has participated, he cannot go back. But in our case, we came to be aware of the legality only after the declaration of the results and receiving the reply to the RTI dated 18th August 2003. If you could refer to the writ petition, page 72, annex to 15. And also, if you...
Okay, you tell the story of your case. Start from the beginning.
Okay.
Yes. What's the matter about?
The matter...
Where's the appeasement?
Your Lordship, this is first advertisement was released on 14th November 2019.
Post of?
For the post of junior athletic coaches.
Post of junior?
Athletic coaches.
Where's the advertisement?
It's in the writ petition. You could refer to page 45, annex 9.
Okay, let's start from there. Annex 9.
Yes, Your Lordship.
Page 45, advertisement.
Page 47, Your Lordship, point 8.
MPSC advertisement.
Yes, Your Lordship.
2019?
Yes, Your Lordship.
Then what do we do? When did you file the petition?
2023, Your Lordship. December.
These people have been when were they appointed?
Your Lordship, the results were out on 2022. And we had also filed a letter of representation on 2022 December.
22, those were out.
Yes, Your Lordship.
Okay, yes. Okay, which page is the
result, Your Lordship?
No, not the result. The advertisement.
The advertisement is
number 8.
page 45, annex 9.
Yes, so we got page 45. Where's the post?
The post, Your Lordship, it's in page 47. Serial number 8, Your Lordship.
Which one are you?
The first.
Serial number 1.
Serial number 1. Point 8, serial number 1.
Coaches, okay.
Yes, Your Lordship.
Yeah, okay. Now what does it say? Candidate should be less than. Read it.
Candidate should not be less than 18 years and not more than 30 years with 5 years relaxation for SC, ST, OBC and 5 years further relaxation in case of SC, ST who are sports persons with national level advertisements or medalist. No age limit for those who are already in Meghalaya government service provided they entered service within the prescribed limit. Your Lordship, there is also corrigendum.
Yes.
Which is in page 52, annex 10.
This is 21. So from 19 to 21, there's no selection?
No, Your Lordship.
Yes.
So the changes over here is like, first they were asking for first it was
issued with the clarification received the Sports Youth Affairs, Sports Department, whatever. Required educational qualification. This is the one.
Yes, Your Lordship.
Where's the change?
The change, Your Lordship, first they had changed the age from 30 to 35.
No, is this?
But our main ground is not this. Our main ground is like first the change here is like graduate. If you could go to the required qualification, graduate in any stream with diploma in sports coaching from NIS Patiala, where they have specifically mentioned.
Okay.
NSNIS Patiala or its subsidiary, regional institute in the concerned discipline. And also in the RTI, they have mentioned, where the reply to the RTI, they have mentioned that only 4 institutes have been recognized. And where the respondents number 5 and 6 are not from NSNIS or any of its subsidiary, Your Lordship.
Patiala and subsidiary.
Your Lordship, if you could go to the writ petition, page number 72, they are the list of recognized institute by the Meghalaya Sports Department, page 72.
No, now they have made a corrigendum before the election, correct?
Yes,
And
Your Lordship.
You don't have the Patiala thing.
Your Lordship.
Are you from a recognized institute?
Yes, Your Lordship. We are from the recognized institute.
Okay. Where is that?
Page 72, Your Lordship.
Page 72.
Yes.
So these, Your Lordship, these are the 4 recognized institutes. But respondent number 5 and 6 do not belong from any of them.
No, but do they belong to this as per the corrigendum? Do they come within the meaning, within the required qualification?
Yes, Your Lordship, but then again, the reply to the RTI is different. They are like contradictory to each other.
Where's the reply to RTI?
So page 70, Your Lordship said page 72 is the reply. You could...
Where's the query? Where's the query?
Page 60 is the first page of the RTI.
Page 60.
Yes, Your Lordship.
Okay. From so and so. He is the petitioner, this Sanbor Rapsang, yeah.
He's not the petitioner.
Then this is provided to someone else.
Yes, Your Lordship.
Where the question, please provide separate copy details, please provide the copies full, please provide art and explanation how to do training, please provide the copies, please provide. Where's the query? From here?
8.
Number 8, please provide list decision, okay.
Page 61, serial number 8.
Okay. Yes. Continue.
So, Your Lordship, we are challenging this that they are not from any of these recognized institute, even though the RTI have provided for it. And
No,
then,
but then,
again, it's
so
contradictory.
Your case that if you don't come from these institutes, they're not eligible for appointment. That's your
Because,
case.
yes, Your Lordship. Because they have not been recognized by the sports department, Your Lordship.
So you mean to say that even though these respondents have been, they are Commonwealth Institute affiliates to this Patiala Institute, that will not make them eligible?
Your Lordship, also, like, my petitioners are more eligible in the sense that they have participated in the state as well as the national level. Whereas the selected candidates have only participated in the state, and respondent number 6 have not participated in any national level. But my petitioners have participated in both the state as well as the national levels, and also they are medalists in the state level.
That's some substance of your case. That's some substance of your case.
Yes, Your Lordship.
Petitioners are here.
Your Lordship,
How
two.
many petitioners are
Two,
here?
Your Lordship. The item number 18 and 19.
What's the separate petition?
Yes, Your Lordship.
Okay, which is So when the corrigendum came out, you didn't have the RTI the reply.
No, Your Lordship.
You obtained someone else give it to you.
Yes, Your Lordship.
Yes. That's the only case. Now where's your qualifications? You put it in a nutshell, or where have you stated in the petition your qualification?
Your Lordship, we have stated the petitioner's qualification in page number 5 and 6 and 7. And the annexures.
So your only challenge is that the corrigendum is wrong.
We're not challenging the corrigendum, but
You want to challenge corrigendum. Then
we are just saying that it's like contradictory.
no, if anyway,
And also,
if you don't challenge the corrigendum, then relief can't be given to you because they're an autonomous body. They've laid down some prescribed criteria. Anyway, yes, Mr. Paul.
Lordships have rightly said it, Milids. The corrigendum was issued, Milids. After the corrigendum was issued, that's when all the applicants, Milids, applied for that post. So they were very conscious of the fact, Milids, that the essential qualifications had been changed at that point of time. Page 47, if your Lordships can have a look, Milids, first.
Of the affidavit
of the writ petition. There's the original qualifications was, Milids. The original qualification as per the advertisement is graduate in any stream with diploma in sports coaching from NIS, Patiala or its subsidiary regional institutes in the concerned discipline.
Where is written?
Page
47?
Page 47, serial number 8, Milids. Your Lordships would find the posts.
Graduate
And scale of pay, Milids, below scale of pay.
Yes.
Graduate in any stream with diploma in sports coaching from NIS, Patiala or its subsidiary regional institutes in the concerned discipline. That was the original requirement, Milids, which was subsequently changed at Annexure 10, page 52.
Yes.
Which now read as 10 plus 2 with diploma in sports coaching in the concerned discipline. So when they applied, Milids, they were conscious of this fact that the original requirement had been
from graduate to 10 plus 2.
10 plus 2 plus, Milids, that NSIS Patiala requirement had been diluted.
But have been deleted.
Lordships. Now the reason why it was deleted is, Milids, deleted or diluted is...
That means, no, at 10 plus 2?
It was 10 plus 2 with diploma in sports coaching, Milids.
Okay.
So the requirement of that...
Sports council was, sports institute was
done away with. So it is only after this advertisement came into being, Milids, that they participated in the selection process.
Okay.
Now the plea, Milids, what they've taken before Lordships is that there are only these 4 institutes which are recognized, even though it may not have a bearing on the matter, Milids. What we've clarified in our affidavit is, we received all state governments, Milids, received instructions from the Ministry of Youth Affairs, Milids, on 27 December 2007. Your Lordships would find it in my affidavit, Annexure 5, page 12.
Respondent number?
Milids, I am respondent 2 and 3.
Yes.
27.
Para?
No, I'll take your lordship to Annexure 5 Collie, my lords. Starts from, my lords, page 12. And this is issued to all my lords, sports secretaries, director of sports of all states and union territories by the Union of India, my lords, on 27 December 2007, if your lordships have it. Request to treat postgraduate diplomas in sports coaching of Lakshmi Bai National Institute of Physical Education, Deemed University, Gwalior, and Netaji Subhash Sonso Patiala at par. I am directed to invite your attention to the subject cited above and to say that the PG diploma course in sports coaching conducted by Lakshmi Bai National Institute of Physical Education, a deemed university which is also an autonomous body of this ministry, are on par with PG diploma courses in sports coaching offered by Netaji Subhash National Institute of Sports, Patiala. The so-and-so Gwalior is a premier institute which was established as a college in the year 1957 and has been upgraded to the status of a deemed university in 1995. It has come to the notice of this ministry that some of the state governments and universities, while making recruitment or issuing advertisement for the post of coaches, have not been considering PG diploma in coaching of LNIPE Gwalior or as equivalent to that of NSNIS Patiala, which has created an anomalous situation. In view of the clarification given, you are requested to issue appropriate instructions to all concerned to treat the PG diplomas of both the organizations at par in all future recruitments. A copy of such instruction may be also issued, kindly be endorsed to the ministry. Thereafter, my lords, subsequently again at page 14, if your lordships kindly have a look, my lords. The same instruction was again reiterated in 2016, my lords. First two paragraphs are more or less the same. Para 3, if your lordships kindly have a look, at page 14, my lords. It is further clarified that LNIPE Gwalior is a premier institute and has been upgraded to the status of a deemed university in 1995, whereas NSNIS Patiala is an institute which is affiliated to the Punjab University for the purposes of award of a diploma in sports coaching. As the institutions enjoy equality of status, it is discriminatory to the diploma holders of LNIPE Gwalior to deprive them of the benefits of qualification, besides causing avoidable hardships to them, and thus needs to be avoided. The whole matter has been considered at the highest level on this ministry. After consideration, it has been decided to once again issue strict instructions to all concerned to treat the PG diplomas of both the organizations and institutes at par in future recruitments and for all other purposes. This would help avoid inconvenience and discrimination to so-and-so.
Now, what relevance are you showing this?
Well, it's the private respondents are graduates from this particular university. And which is why...
No, but your prescription doesn't say anymore.
It was not required. The reason why that, Malaj, I would have to also justify why it was diluted or deleted.
Why only 10 plus 2 diploma from a
because earlier, my lord, it was only NSIS.
Yes.
Subsequently, these letters of the ministry were also brought to our notice, my lords. That's why that requirement was done away with. The only grievance of the petitioner is, my lords, that they say that as per that, as per that RTI, it is only these 4 institutes. This clarifies this position. But the fact of the matter remains, well, is that when they applied, the essential qualification had already been changed.
Yes, that's all.
And both the private respondents have that.
Support your case? Any authorities?
No, your lordship.
Any authorities?
No, your lordship.
Why? This is the first time you're arguing. You should come well armed, even if every case is a good case. Remember that.
Your lordship, even though they have provided instruction from the central sports ministry, but there have been no instructions from the state government because it acts just as an instruction. Also, I would like to say, like, if they had already done away with it, why had they issued an RTI later on after all the recruitment had been done, stating only those 4 institutes as recognized? Why hadn't they included the others?
One thing that goes against you is that at the time of when you applied, all these were already, you know, what do you call it? Known to you. What are the qualifications? So the advertisement is the route, you know, it's where, you know, it's point A from where it starts. So if you like eligible as per advertisement, you apply. So then if you had any grievances with the advertisement, you're from Patiala.
Yes, yes, your lordship.
You're from Patiala.
Yes, your lordship.
That is one. Yes.
May it please your lordship.
What role do you have to play?
Lordship, because what happened, Your Lordship, is not a case. The case of the petitioner here is not a case of that the official respondent here in Your Lordship had committed illegality. No, the only grievance, Your Lordship, is that the private respondent herein, they do not have that qualification from those institution, Your Lordship. In fact, that, Your Lordship, has been clarified by my friend, Your Lordship. And Lordship, it is not true, Your Lordship, because what happened, Your Lordship, first thing, there was an advertisement of 2019, and then in 2021, that has been changed, Your Lordship, because what happened, Your Lordship, we have the correspondent, as pointed out by the Council for the MPSC, Your Lordship, that the institution of which the private respondent had.
Okay, just one thing. Now, the only point she has is that the state recognizes only these 4 institutions, National Institute of Sports.
No, Your Lordship.
So the thing is that whether the advertisement is wrong. You see, that's the only thing.
No, Your Lordship, it can't be, no, the advertisement cannot be wrong, Your Lordship. It's not wrong, Your Lordship, because even this corrigendum also had been published in 2 newspapers, Your Lordship, in the Meghalaya Times as well as in Janera. And after that, after a lot of people, Your Lordship, took part in the selection process.
What else you wanted to say?
First, Your Lordship, I would challenge the maintainability, Your Lordship. As Lordship has rightly pointed out, Your Lordship, that the corrigendum was not put to challenge, Your Lordship. Number 2, Your Lordship, the locus. The locus.
Why locus?
The locus, Your Lordship.
He was an aspirant.
Lordship, yes, they took part in the selection process knowingly, Your Lordship, voluntarily, without any murmur, Your Lordship. Only after the result is not favorable to them, Your Lordship, they cannot turn around, Your Lordship, or cannot question, Your Lordship.
Yes.
Then, third point, Your Lordship, is that, as I have submitted, Your Lordship, this where the corrigendum had been widely published into local newspaper, the Meghalaya Times, as well as in the Janera. It is not, Your Lordship, that it is a game of hide and seek, Your Lordship. It is fair. The selection is transparent, is fair, Your Lordship.
Yes. That's it.
Then, Lordship, the facts, the contention that the private respondent did not have the required qualification, Your Lordship, that is not correct, Your Lordship. In view of the facts, Your Lordship, kindly come to page 11, Your Lordship, of the affidavit filed by the state.
State is which affidavit?
Lordship, this is by respondent number 4, Your Lordship. Director, Sport and Youth Affairs Department. Lordship, kindly see. Kindly see, Your Lordship, yes, I'm directed.
1 and 4.
Lordship, yes. Whether Lordship is having my affidavit.
Yes. No, 1?
By respondent number 4, Your Lordship. The affidavit has been filed by the respondent number 4, the Director of Sport and Youth Affairs Department. Let me assist, Your Lordship.
Oh, yes, Jian Ranja.
No, Your Lordship, it is filed by
Yes, okay.
Shrimati Isawanda Lalu, Your Lordship,
Yes.
Director of Sport. Lordship, kindly come, before that, Your Lordship, if Lordship kindly come to para 7, Your Lordship, of the affidavit.
Yes.
That has been published, Your Lordship, on 2nd 4, 2021 in Janera and Meghalaya Times on 1/4. Then, Lordship, so far the RTI application, Your Lordship, at para 11, that has been explained, Your Lordship. Why? Then, Lordship, the second paragraph of
So you
the
say that The option is wrongly furnished. Is wrong information given?
Lordship, yes. It's Lordship, yes.
Who's this PIO? You suspend him.
Lordship, we'll have to.
Then? He'll be suspended. He's supposed to be an information officer.
Lordship will say that
yes,
as disabled would have been any institute college recognized by Government of India through the Ministry of Youth Affairs, Your Lordship. Lordship, that is that was the mistake. Then Lordship, kindly come to page 11. 11. Then Lordship, these are the institute recognized. This is the letter issued by the Undersecretary to Government of India, Your Lordship, to the educational secretaries of all state and union territories, the sports secretaries. Then Lordship, kindly come to page 13. This same, Your Lordship. Then Lordship, kindly come to page 15.
1 second.
Lordship.
No, the treatment of these other institutes at par with Patiala and so on.
Lordship, yes. So these are recognized by the central government, Your Lordship. Then, if Lordship kindly come to the last, that is at page 17. This is the.
You say there's a mistake that the RTI.
Lordship, yes. Lordship, we have admitted, Your Lordship, in para 11 of the affidavit, Your Lordship. Lordship, if Lordship kindly come again to para 11.
On what basis then the information was given? That fellow is not aware about the
maybe, Your Lordship.
letters also.
Maybe, Your Lordship.
Who's the PIO? He's a junior officer.
Most of the Your Lordship. Assistant Director, Your Lordship. Public Assistant Director. Maybe by mistake, Your Lordship.
Okay.
And that is only a. That's all, Lordship. Lordship.
What about para respondents? Number 5, Mr. K.S. Kinting. Yes.
I'll just endorse what my.
Where's the qualification? You're from?
I'm from the.
So as per the advertisement, you're eligible.
Yes.
Where's that? Don Kupar Kharjana. Mola Presbyterian.
Jana.
Which paragraph is stated your qualifications in your affidavit? Para 4, Gwalior.
Yes, Gwalior, my lord.
Yes, and who's the other respondent?
And I've enclosed also the full particulars also by lord.
In para 4, you've made a chart, very good, yes.
Yes, ma'am.
Yes, and the other respondent?
Yes, my lord. My lord, can I please share this note? My lord, it has everything in it.
No, where's the affidavit?
My affidavit, my lord. This is there.
Okay. Sylvester Lingdo?
Yes, my lord. I am.
Oh, no,
first
sorry.
Number 6.
You are?
I am Fidela, my lord. Fidela. My name is Fidela.
Sorry, 1 second. Some. 5120.
My lord, it'll be very easy. Please allow me, my lord.
No, just let me see your affidavit.
Yes. Thank you.
This is, okay. Okay. That's how you note what is the note.
My lord, if I may take you paralyzed, if I may.
Yes.
This is the only office, this is the only recruitment rules. The first paragraph, my lord, which is dated 23/12/2005. This is the only recruitment rules with regards to the coaches, junior coaches. My personal details, my lord, the personal details of the petitioner is at page 417 to 44 of this writ petition. the various notifications by the central government recognizing my universities, my lord, start at dated 27/12/2007 at the second page, my lord. Those are the various notifications recognizing my university.
I want to see the institute.
Okay, my lord, I'm taking you. My lord, you will find my...
You're from?
I am from Gwalior, my lord.
Okay. It's Lakshmi Bai in National Institute of Physical Education.
Yes. My qualifications are at... Just give me 2 minutes, my lord.
Yes.
Yes. No, I have it. My counter affidavit, page 30, my lord.
Page 30.
Yes, my lord. These are all my qualifications. Beginning at page 30, I have Lakshmi Bai National Institute of Physical Education, Gwalior, MP, India. This is at page annexure 6, my lord. And my lord, I have participated in the India International Agriculture University, which they say I don't have a national participation, but these are my certificates, which is at annexure 15, page 39, and annexure 17, page 41.
Yes.
Yes, my lord. And then, my lord, we have the various notifications from the central government. They are about...
already been placed.
Yes, my lord. Then we go to the service. My lord, there is a letter which has come from the Sports and Youth Affairs Department, which is, I did not page my, which is dated 27/9/2019, which they say that service rules are yet to be finalized. It's part of the counter affidavit of the respondent, number 2 and 3. Then we have the advertisement dated 14/11/2019.
Yeah, that we've seen, yes.
Yes, my lord.
Any
you've seen
extra
that? Yes,
submissions
the extra thing I'll tell you, my lord. Yes, I will tell you, my lord. This is at, my lord, if you go to date 15/12/2021. 15/12/2021.
Which annexure?
It is annexure. It's a counter affidavit of my annexure 26, my lord.
Okay, recruitment for the post, this one.
Yes, my lord. So here, these are the names of ineligible applicants, my lord. Asking them if they have any reasons against the corrigendum, which none of the petitioners have names appear here, my lord. And then
this is a type copy of this one. This MPSC notification notice.
I don't have a type copy, my lord. I'm sorry.
MPSC notice.
Yes, my lord. These are ineligible candidates as per the corrigendum, so they've been asked to reapply, but the names of the petitioners were not there.
No, they're eligible, the petitioners.
Yes. So this is what I'm trying to say. So, my lord, they did participate in the advertisement, I mean the interview, personal interview. They did take part, but they were found to be unsuccessful.
Okay, then we'll pass orders.
My lord, I'm relying on 2 judgments, please.
Yes. Let's have them.
One is 2022 SCC online. I will pass copies to you.
22.
I'll give you marked copies, my lord. Yes. It is in my note of submissions too, lord. My lord, I have mentioned.
Pass orders, we won't reserve it also.
19 connected.
Next matter is connected, same facts.
Yes, my lord. I thought, my lord, I should read the judgments, but if it's okay.
It's all right, I mean, yes, citations are not.